Hi, my name is Robert Shelley with Shelley Law, and my law firm assists physician assistants with employment contract and independent contractor agreement issues. Today I'm going to talk about for cause termination and a physician assistant contract, so both employment agreements and independent contractor agreements. So there's kind of three ways of terminating contract. One could just be a mutual agreement to terminate it. Either party just says, look, it's not working out, and then both parties agree, and then the contract just ends. Two, without cause termination. So there should be language that says either party can terminate the agreement at any time with a certain amount of notice to the other party, usually somewhere between 60 to 90 days. The reason why that is in there is to allow for continuity of care. At least that's the rationale behind it. If you're a healthcare provider, let's say you're a PA in private, primary care practice or something like that. You're scheduled out 4 weeks in advance. If you just came in and said, hey, I'm leaving tomorrow, well, you're going to have this full schedule of patients that have no provider. It can be a problem for continuity of care purposes. And that's why normally 60 to 90 days for without cause termination is in there. Allows them to transition patients if needed or find a new provider, hopefully. All right. The third way is with cause termination. That's what we're going to talk about today. So with cause termination simply means one party is in violation of the agreement, and then, for whatever reason, they don't fix the problem. Either party can normally terminate the agreement immediately. Now, with a couple of caveats. One, there needs to be a cure period in the contract. So what a cure period means is if one party is in breach, you would give notice and say, hey, you are in breach of the contract. And then the cure period would allow the breaching party to fix whatever the problem is, usually somewhere between 1 to 3 weeks long. And then if they were to fix that, whatever the issue is, within that period of time, then the other party could no longer terminate it immediately. Now, let's give an example. So let's say you're a PA, your contract has productivity bonuses and they're paid out quarterly. You hit your bonus, quarter comes, employer doesn't pay. So you say, look, you're in violation of the agreement. You agreed to pay me my bonus, you haven't. And then they would have, say it's a 10-day cure. You have 10 days to fix the problem. If they don't fix the problem, then it would be the option of the PA to terminate the contract immediately. What is a good cure period? I think 2 to 3 weeks is plenty of time for someone to fix an issue. It's probably a generous amount of time, but there does need to be some time associated with that. Now, language is important. So any employment agreement that you're going to get as a PA probably has a huge section about all the things that the employer can terminate the PA for and then terminate the contract immediately. And many times there's absolutely no language at all that allows the PA to terminate the contract if the other party is in breach. Now, that if the language is absent, it doesn't mean you can't terminate the contract, but it is nice to have a roadmap of what's going to happen if the employer is in breach. So as a PA, you need to think, all right, I do need language that allows me to terminate the contract for cause, and then maybe list some of those issues. How? Now, what are the main issues the employer lists? Obvious things. You lose your license to practice. You lose your DEA registration. The PA is uninsurable. So things that prevent the PA from being able to provide care are obvious reasons that the employer can terminate the contract. There are also going to be probably a lot of kind of vague reasons conduct detrimental to the collegial environment in the practice, or some kind of super vague language. Be careful about signing that, because then they could theoretically terminate you for cause for kind of things that are probably in the gray area of whether they rise to that level or not. So as long as you have some language in the agreement that allows you to terminate it for cause, I think that will, one, make things easier if they are in breach, and then just, sets the standards for both parties. Now, to provide notice needs to be written, needs to be given to them in the manner that the contract says proper notice is given, usually hand delivery, certified mail, that type of thing. So if you just verbally tell the practice that they're in breach of contract, that's not enough. You need to write a letter so that there's a record of it. Anyway, that's a little bit about for cause termination and a physician assistant contract. If you have any questions, feel free to leave them in the comments, or if you need more assistance, you can contact my law firm at the contact information listed below in the description. And I appreciate you watching the video. All right, thanks. Bye.